Thank you, Kara, for that nice introduction. Bishatabino, Debra Harry, Minania. I'd like to acknowledge the traditional owners of this land. It's an honor to be here. I would like to acknowledge the Bioneers team, particularly those who have put together such a fantastic Indigenous Peoples Forum. And thank you again for the invitation to come and participate. My native name, my spiritual name, is Kwinat Pukut Mogotni. I'm a chief eagle horsewoman. And a part of who I am as an eagle spirit, as a horse spirit, is to fly far, fly high, and see far. And it seems like that's what I've been doing with a lot of my life in the work that I've been doing to protect Indigenous peoples' rights to their biodiversity, to their knowledge systems, and to our right of self-determination. And so I thought what I would do today is to talk about what I'm seeing, bring that information back to us so that we can think about what's taking place. A big part of my work has been to look at the field of biocolonialism, which is a process. It's a very complex process. It has many actors. And it's a process that facilitates the misappropriation, the commodification, and then the assertions of ownership of Indigenous peoples' biodiversity and knowledge for other people's gain, for other people's use. And so the players here can be states. There's state actors involved. The players can be corporations, and sometimes even our own folks, unknowingly, when they get coerced into participating in some of these schemes that are being developed that facilitate this misappropriation. So that work has taken me to like the Convention on Biological Diversity, a United Nations convention that has 192 state signatories who have ratified the convention. It's essentially an international treaty. The convention has 3 goals: conservation, sustainable use, and then the fair and equitable benefit sharing from the commercialization of the world's biodiversity and traditional knowledge. So conservation, sustainable use, good things. But once you start to look at this third pillar of the convention, the benefit sharing from the fair and equitable use of genetic resources, what that has turned into is essentially a genetic free-for-all, where states need genetic materials to produce their new products. States and corporations need genetic materials to produce new products in the form of genetically modified seeds, medicines, and so on. So the Convention on Biological Diversity, through a new sub-treaty called the Nagoya Protocol, sets up the international framework for how states will access and commercialize genetic resources among themselves. So you can imagine that there's going to be some natural divisions here. You have user countries such as the U.S., the European countries, countries that have a lot of technology who need biodiversity to continue their work. And then you have provider countries. These are the mega diverse countries like Malaysia, like India, like Brazil, and so on, who have a lot of biodiversity, but not so much in terms of the technology to exploit those resources. So this is a global framework now that has been established through the Nagoya Protocol that sets up the rules for how you access genetic resources and then share in the profits from the use or the exploitation of those resources and associated traditional knowledge. Okay, so where do Indigenous peoples fit in this framework? We've been treated as affected third parties, but not principals in these discussions. Indigenous peoples have been marginalized in the elaboration and the finalization of the text of this treaty. So things such as subjecting access and benefit sharing rules and policy to domestic legislation, which gives states, every state in the country, every state in the world, the freedom to decide how they're going to address Indigenous peoples' rights. Rather than setting up an international standard that states must aspire to, it subjects these rules to national legislation. There's text in there, such as in Articles 5 and Article 6, that refers to the established rights of Indigenous peoples when it comes to access and benefit sharing over genetic resources and traditional knowledge. So if you think about where we are in the US, are there any established rights that specifically say Indigenous peoples have the right to their genetic materials or their indigenous knowledge? Can we claim that we have established rights, or can any Indigenous peoples really claim that they have so-called established rights? Well, of course we have rights over these things, but is it specifically, detailed in law? Maybe not. Maybe not. There's also, if you look through the text of the Nagoya Protocol, liberal use of really vague phrases such as appropriate, or when applicable, or subject to national legislation and domestic law. So that's one treaty-making process that we followed carefully. We worked very hard to try to get language in that would protect the rights of Indigenous peoples, respect our right to free, prior, and informed consent, and so on as states go about this process. And I would say that, by and large, we lost that fight. We lost the fight. We lost the ability to establish in international law a legal framework that respects Indigenous peoples' rights to their biodiversity and traditional knowledge. Now, let's jump over to Geneva, the World Intellectual Property Organization. The World Intellectual Property Organization is also establishing treaties. This time, they have an intergovernmental committee called the IGC that has the mandate to negotiate a legal instrument or instruments for the effective protection of traditional knowledge, genetic resources, and traditional cultural expressions. That's a mouthful, so what does that mean? Again, it's a treaty-making process. States are establishing international standards that are supposed to protect traditional knowledge, including Indigenous peoples' knowledge, and our genetic material, meaning our biological material, the plants, the seeds, the medicines, all the things that we have a relationship with, our wild rice, our salmon, you name it. All living things have biological material. They all have genetic material within it. And this time, traditional cultural expressions. What is that? States are establishing protection for traditional cultural expressions such as your designs, your songs, your dances, maybe your language. Whatever we do to express who we are is being covered by these so-called protections. Now let's think about where this is happening. This is the World Intellectual Property Organization. WIPO has the mandate to promote and perpetuate intellectual property rights around the world. So guess what? These so-called protections are trying to force Indigenous knowledge systems and genetic and biological material into the intellectual property framework. They're two polar opposites. Indigenous systems are natural systems. They're meant to protect what's ours that has been a part of who we are since the beginning of time, and it belongs to future generations. An intellectual property right has an expiration date. Once that expiration date passes, say for a patent or for a copyright or for a trademark, once it passes, once it's expired, and all intellectual property rights expire, Once it expires, it goes into what's considered the public domain, meaning it no longer belongs to anybody and is available for free and open access. Anybody can use it. It no longer belongs to you. So if Indigenous peoples get caught into this system of putting traditional knowledge under a copyright protection scheme or putting our biodiversity within a patent protection scheme, it really literally is a one-way track out of our communities, out of our control, and away from, it alienates whatever was protected within that scheme. Francis Geary, who is the General Director of WIPO, said perpetual protection is not on the table. So what we need is perpetual protection for what is ours. That's how long it must last. It's for our future generations. Everything about who we are is for our future generations. There's no expiration date on our culture. There's no expiration date on our relationships to our land. But they're saying that there's no perpetual protection on the table. There also seems to be no standing for non-IP or non-intellectual property protections in these negotiations. I've been following these negotiations for maybe 10 years now, and non-IP protections are on the table. They don't have standing. They won't carry any weight in these international treaties that are being developed. I think we're going to see these treaties fully elaborated in the next 1 or 2 years. It might be one treaty, but I think it'll be 2, 3 treaties. One dealing specifically with traditional knowledge, which would incorporate Indigenous knowledge. One dealing specifically with genetic resources, and one dealing specifically with traditional cultural expressions, because that's the way the draft text is shaping. I'm hearing things such as states assert that they are TK holders and that they should be considered the beneficiaries in these draft articles, in the draft documents. What would that mean if states were recognized as the holders and beneficiaries and owners of traditional knowledge or genetic resources? And you think about settler states such as where we are, the United States. Traditional knowledge comes from a historical connection to the land. They're one and the same. You've heard speakers speak about that yesterday and today here. Talking about traditional knowledge being a part of a peoples that has a history to it and connection to land. Settler states can't claim that. They can't claim that. They can't be holders of traditional knowledge if they've only been here for 100, 200 years, 500 years, or whatever. It doesn't come from that connection. What it would set up, though, if they are recognized as owners and holders of traditional knowledge within these international treaties, is they would become gatekeepers. They would have the right to say yes or no about how Indigenous knowledge systems could be used and what can be done with our biological resources. The other thing that Indigenous peoples are dealing with in these international fora is an unfair level of participation. Indigenous peoples are relegated as observers. We are not parties. We are not members of the United Nations. We have no right to vote. And so how that plays out on the ground then, or in these meetings, is that many times we don't have a voice. While states are discussing how they're going to address Indigenous peoples' rights, many times Indigenous peoples do not have the ability to make an intervention on their own behalf. We can put up our placards and call for the mic, and those, the chairs of these working groups have no obligation to call on us to hear what we have to say. And so it's very unfair and unequal level of participation. I wanted to talk a little bit about some upcoming work. This is the World Conference on Indigenous Peoples. And I asked Tara to put up a document. So the UN, the United Nations, passed a resolution And what they passed is an agreement or a commitment by states to have what they're calling a World Conference on Indigenous Peoples. But that's really a misnomer because the official title of the event is called a high-level plenary, to be called a World Conference on Indigenous Peoples. So if you think about world conferences, there are things like the Rio Summit, right? There are things like the World Conference on Racism, the World Conference on Women, where there's official preparatory processes and there's a lot of global preparation, and the UN every state sends their high-level representatives to these meetings, and there's some kind of a plan of action that comes out of a world conference. Well, this is called a high-level plenary, to be known as the World Conference on Indigenous Peoples. So a high-level plenary of the United Nations is something quite different. It's a meeting of states in their typical, usual fashion in New York City, where maybe some observers are allowed to come in, but those observers really don't have a voice. And that's what I wanted to share with you. I wanted to share with you how the World Conference on Indigenous Peoples' modalities resolution has shaped up. So what's happened is the General Assembly said, yes, we're going to have this so-called World Conference on Indigenous Peoples. And just last month, they passed the modalities resolution, which is the resolution that defines how the conference will take place. So let's just take a look at what we have here. And what I want to share with you and what you can't see when you read a document, you can't see what language fell off the table. All you see is the finished piece. So I want to show you what fell off the table as this modalities document was being negotiated. So it has preambular language, and then it has decisions. It has specific decisions. In this case, it has 9 points. So in the preambular language, which really shapes how, kind of like the intent and the purpose behind the document, under the first paragraph, it says that recalling that the United Nations Declaration on the Rights of Indigenous Peoples, which addresses the individual and collective rights of Indigenous peoples, and that's where this final document stops. But what fell off the table, this version deletes the reference to the right of self-determination and the right to participate in decision-making in matters that affect us. So that language is in earlier drafts, but in the draft or the final text that was approved by governments, this is what's left. That's no longer there. Let's look at the next one. Recalling further all relevant resolutions of the General Assembly, the Human Rights Council, and the Economic and Social Council relating to the rights of Indigenous peoples, full stop. What it deletes, and to their participation in United Nations processes and bodies. So this idea that Indigenous peoples are going to be actively participating in this high-level plenary, I think you're kind of getting the drift here. Let's drop down to decision number 1. This World Conference had been discussed previously to be maybe 3 days. Then I heard 2 days. Final decision, 1.5 days of high-level plenary. Let's drop down to 3B. The speakers to be determined by the President of the General Assembly, consulting with states to decide who those speakers are. After consultations with member states, what fell off the table was also to consult Indigenous peoples. So a mandate by the President of General Assembly to consult Indigenous peoples about these high-level speakers, to consult with us, that's off the table now. Let's drop down to H. This is a big one. Organizations and institutions of Indigenous peoples interested in participating can go through a process to get registered. But who gets to participate is decided by states. The other thing that's important is that instead of what earlier text had suggested that it was indigenous peoples, indigenous nations, councils, parliamentarians, governments, organizations, and institutions would be eligible to participate. References to indigenous peoples' nations and parliaments and so on, which puts us at an equal par with states, right? Government to government has fallen off. Now indigenous peoples' organizations may participate, and it's all to be decided by member states. So states will decide who gets to participate. As a side note, at this World Conference, a maximum of 300 people, indigenous people, will be able to participate. It's probably going to be more like somewhere between 200 and 300, because they'll only allow a mixture of 300 observers, which could also include non-indigenous NGOs and so on to come. So this is our World Conference. Now let's look at number 9, which is the last one. Decides that the high-level plenary meeting of the General Assembly, to be known as the World Conference of Indigenous Peoples, shall result in a concise, action-oriented outcome document. Request the President of the General Assembly to prepare a draft text on the basis of consultations with member states, as well as indigenous peoples. What's deleted right there is in an inclusive process. Okay? And by taking into account the views emerging from paragraph 8 of the present resolution, to convene an inclusive and open formal process of consultations at an appropriate date, blah, 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 okay, prior to the formal action at the high-level plenary. This section puts decision-making on the outcome document solely in the hands of member states. So what I'm asking people to do is to, you know, too often we think, without critically thinking about things, that this is a good thing. It sounds like a good thing. Access and benefit sharing sounds like a good thing, right? Protection for indigenous knowledge or traditional knowledge system sounds like a good thing, but you know what? The UN isn't always our friend. It's a double-edged sword. The work at the United Nations is a double-edged sword, because this is their forum. This is their place. They are the people in the final decision-making positions here. And indigenous peoples do not have a fair shake. Yes, we made gains. We've made gains through the years. And one of the crowning achievements, of course, is the UN Declaration on the Rights of Indigenous Peoples. But if you don't carefully follow even what happened to the UN Declaration, in order for it to get passed, there were some compromises that had to be made for that text to be passed. And some of those compromises are serious compromises. And so I'm asking people to be critical about these things and to understand where they come from. I often hear indigenous people saying, oh, you know, the permanent forum is our forum. It's our place. It's where indigenous issues are discussed. But it's not entirely our forum. Yes, we're active there, but so are states. So it's very important to be careful about and to be critical about what we see coming out, to follow these negotiations carefully, to understand the text and how that text was achieved at the end of the day. I was listening to an exchange yesterday between Oren Lyons and one of the chiefs that are visiting us from indigenous chiefs from Latin America. I think it was Marlon Santi, who spoke here earlier. And Marlon told Oren, who has been there since the beginning, right, since 1972, when indigenous peoples went to the United Nations in Geneva and demanded a place at the table as peoples and nations of the world. Indigenous peoples are peoples and nations and have the right, just as all other peoples and nations of the world, to have a seat at the table. 1972, that's why Indigenous peoples went to the United Nations. Dealing with colonizing governments that couldn't give us a fair shake. So I was listening to Oren and Santi yesterday, and Santi says, well, Oren, thanks for getting us in the United Nations. And he says, now we're fighting the United Nations. And it's true. It's true because gains can be made there. These are international standard setting processes. But as long as our rights are diminished and our ability to protect ourselves fairly on an equal basis are denied, it's going to be really difficult to get a fair shake. And I would say probably impossible to get a fair shake. So what does that mean then? What do we do? What do we do? I can tell you what some people are doing that I'm not happy about. Some people are staying in the process no matter what, because there's the ability to be there. Someone's paid your plane ticket, so you're there and you're in it no matter what. But I'm concerned about that. I'm concerned about that because I think as Indigenous peoples, we have to continue to stand our ground no matter what. We have to take a protective stance. We have to take a fighting stance when we have to and stand our ground because you know what? Nobody else is going to do it for us. I think about the Haudenosaunee people and I think about the Turo Wampum as a treaty, as a model. It's a model that respects sovereignties. It's a model that respects the right of peoples to self-determination. It's a model that reflects sovereignties floating down the river of life as equals. And I think that's a vision that continues to inspire me. And when I hear the Haudenosaunee people talking about the Turo Wampum, one of the things they say is, you can't have your foot in the canoe and in the ship at the same time. And as an Indigenous person, you can't just go to the ship and expect to be who you are. Because if you go to the ship, you leave everything else behind. You leave your identity, you leave your whatever, your culture, your language, and so on behind because you've chosen that path. You've chosen that path, the path of the ship. But what about those of us? We have to stay in our canoe. We have to stay in our canoe and continue to protect what's important to us for future generations. That's what motivates our work. That's where my heart is. We have to be proactive and to defend and protect. That's our responsibility, and that's what we have to do. One of the things that has been important for me is to work with the next generation of leadership in my territories and in my homelands. And so I've started an Emerging Indigenous Leaders Institute. And it's very much along the lines of what Dr. Greg Kahete talked about yesterday, that we have to develop our own Indigenous pedagogies. We have to develop our own forms of education in a way that helps our young people be all that they can be, but mainly starting with who they are. That becomes the foundation. And then help them grow from there. And so that's what my work at home has focused on. I think in the end, some people say, oh, you're really hardline, you're really non-compromising, or, you know what? It doesn't matter to me. What matters to me is that I'm doing the best that I can do for our future generations, because they're the ones that live with the impact of our decisions today. Those unborn children, those unborn generations yet to come are depending on us in a very profound way to take care of them. And that's our job. That's all of our job. We have to ask ourselves, what are you doing for those generations that are still coming? what kind of world are they going to live in? If I don't do what I can to stop genetic engineering, to stop the manipulation of life, the commodification of life, or the diminishment of Indigenous people's rights now, that's the legacy I leave them. So I encourage you, as Indigenous peoples, as non-Indigenous peoples, to work with us, to fight for what's right, to fight for what's fair and just, and help us protect, in a real sense, our world. Because intellectual property rights is not the path to protection. That's the path to commodification. We have to protect what's ours based on our own systems of what we know of nurture and balance and protection, regeneration, and all of those kinds of things, those principles that we live by. That's what's important for us, and that's what's going to benefit all peoples, all future generations. So thank you again for the opportunity to speak here. Kara, thank you again for inviting me. It's been my honor to present.